I said it. Ndikutofarira mushana yandikuseka kuti ainini handichabuda muofisi.
Okay, good afternoon. It's just after 12. My name is Memory Ngui. Welcome to this particular session where we've got Arthur Marara. Arthur is going to take us through the basics of employment contracts. It's a topical issue across the board, the issue of employment contracts. Just gauging by the number of questions that have been sent to my inbox, you can understand how important this particular issue is. So I would like to welcome Arthur. We have partnered with Arthur here as the industrial psychology consultants, and we are bringing you this under our Human Capital Hub, which is really a portal and for human resources content. You can also follow us on YouTube. This session is live on YouTube for those that may be struggling to join via Zoom. Arthur, I think I'll give you a few minutes to introduce yourself. Welcome, and thank you very much, young man, for agreeing to be part of this particular initiative that we have. This is one of the first sessions that we're going to have with Arthur, and we have many more on any topical issues. Mind just the housekeeping issues. If you've got any question, please put it in the chat room. We have 600 people registering. So far, we've got 121 people online. we hope to get more people as people join in. We have only just started. So Arthur, welcome. I will hand over now to you to start the session.
Thank you so much, Nkoma. I'm so honored to really be part and parcel of such a wonderful event. Now, I think I might just have to quickly share the screen. I'm seeing the numbers are also rising. Thank you so much, guys, for ensuring that you're part and parcel of such a wonderful conversation. I'm trying to share my screen quickly so that we can have some talking points easily. I'm going to use PowerPoint, then we just get to have some discussions on this very important subject. I just want to say thank you to Nkoma Memory for the great work that you're doing. I've really learned a lot from you, and I think many people are also here because they respect the brand that you've built over time, and obviously the benefits that they are deriving from the various postings and sharings that you're doing across all media platforms. So today we want to go through a very topical area, which is an area that I'm also passionate about. I've been practicing law for the past 12 years. I think many people know my other side is a public speaker, but public speaking, of course, that's another part of me, but this is my main area. So I want to take you through this area of law. And like we shared in the past, when we're inviting people to this conversation, labor matters can also be very expensive depending on how you handle them. That's why today we want to have a conversation around how can we get an understanding of contracts of employment? How do we get to do that? So today, pretty much, I'm going to take you in a law class. Not that I'm going to be dazzling you with legal terms and so forth. I'm going to take you through the basics and put you into a position where you're able to now understand some of the basics that are involved in terms of law contracts. So that's a bit about me. I want to inspire people. I want someone to look at me and say, because of you, I didn't give up. I think that's one of the signatures that I've consistently seen the majority of the times where I'm speaking. So the scope of today's conversation, I'm going to cover with you what is a contract of employment, because this is where many people also get it wrong. So the bulk of the problems, they start from a misunderstanding or a lack of understanding of what is meant by a contract of employment. Then number two, what laws govern a contract of employment? By the way, the moment you step into the realm of contracts of employment, you're already stepping into the realm of the law, meaning you need to know the specific laws that govern contracts of employment. So if someone has done X, Y, Z, you're an employer, have done X, Y, Z, the question is, in terms of what law is it supported? That's why we need to have an understanding of what are the laws that govern contracts of employment. Number three, what are the terms of the agreement? What are the terms of this particular contract? What did you agree on? We're going to look into that. Then, what are the elements of a valid employment contract? A number of times we take these things for granted. That's why I really think it's very important for us to go back to the basics and start demystifying some of these things. Then the formalities of a contract, then implications of Section 12 of the Labor Act, which I think is quite central to the conversation around contracts of employment. Then I'm going to talk a bit on variation, because that's one of the topical areas as well. Then eventually I'll try to close on termination or notice. I've just selected that, but in the next conversation, we're also going to be going into greater detail to look into those specific aspects and see how best we can also get to learn. So what are some of the common areas of conflict in contracts of employment? This is what many people are going through right now. This is some of the things that business is actually going through right now. The interpretation of a contract itself is actually problematic for many businesses. So that's why you find you've got disputes. Some of them, they spill into labor platforms where people are saying, we don't understand 1, 2, 3, we're not agreed on 1, 2, 3. Alternatively, in breach of 1, 2, 3, and you're saying, I'm not in breach. Issues to do with bonuses, I'm going to explain them as well later on. Promotions, benefits, unilateral variation of contracts, non-payment of agreed benefits. I'm talking about things that usually affect many businesses, many individuals. Leave, things to do with leave. Termination of contracts, quite topical as well. Disciplinary hearings, retrenchments, terminal benefits. With the blessings of Mkomango, depending with the feedback, we're also going to be running trainings on some of these things so that you also get to an appreciation of how these things run and operate. Then I want you to note one thing. The time that we're living in during COVID-19, there was a lot of conversation around what do businesses do. Many businesses were closed, but the obligation to pay salaries was not suspended. This also goes back to the conversation around understanding a contract of employment. Can you stop paying salaries simply because your business is not open? what are the available options if your business has been affected by COVID? Alternatively, your business is going through some operational challenges. What are some of the available options? And these are the questions that businesses, individuals, trade unions are obviously asking. And we're going to cover that as we'll be going through this particular conversation. Like I said, I don't want to take anything for granted. I want to start with the basics. What is a contract of employment? A contract is simply an agreement between two parties. That is what a contract is about. It's simply an agreement between two parties. So it comes into existence when one person enters into another, and that other person becomes the employer to render personal service. The emphasis there is personal service. And many people, they take some of these things for granted. An employment contract is where an employee has to specifically render personal service. In other words, you don't assign someone to do it for you. You have to render personal service. Then you are going to be under the control of the employer in return for remuneration. So if someone is working, it means there is an obligation as well to pay remuneration. And I think that's where you find some of the problems where someone has worked, they have not been paid, and what are the issues that are involved. We're going to be talking about that. But that's a simple definition of a contract of employment, and this is provided for in terms of Section 2 of the Labour Act. And when you go through that, you also get to an appreciation of this. So what laws govern a contract of employment? And this is where I think many people also miss it. The first law that governs contracts of employment is the Constitution of Zimbabwe. Many people, they don't get to study at this level. The Constitution is the supreme law, meaning whatever that you agree with has to be consistent with the provisions of the Constitution. So if we find certain provisions that are going against the Constitution, pretty much it means those provisions, they are null and void to the extent of the inconsistency. Then the next source of law that also governs contracts of employment is largely the common law. So the common law is where the employment law back then, as we knew it, started from. So it became common law. Now it's common law is modified by statute. So back then in 2017, many people are aware of the Zua case, where the Supreme Court confirmed the common law rights of the employer to terminate a contract of employment or notice. That's the common law. Secondly, now the Supreme Court has also affirmed that an employee can be terminated. The contract can be terminated once it has been proven that the conduct complained of goes to the root of the contract of employment. That's a common law position. And the position of the common law is not changed unless the statute is expressly alter the common law position, which is why many people found themselves dismissed over a matter which ordinarily in terms of the code of conduct cannot be dismissed. The law is quite settled. The common law can only be amended expressly by a statute. And that's one of the things that people need to understand how the law operates. So we've got the Constitution as the supreme law, then the common law. And the common law, what it does, it also imposes duties and obligations. Similarly with other sources, they also impose duties and obligations. And the role for an HR practitioner, the role for anyone who is studying employment relations is to understand the obligations imposed by the Constitution, obligations imposed by the common law, also get to understand the obligations imposed by the Labour Act. So the Labour Act is now the legislature intervening and coming up with specific provisions to govern contracts of employment. So the rest of the things that we find there in terms of the Labour Act, the goal is to say, let's govern this. Let's govern a contract of employment. That's why you need to make the Labour Act your friend. You need to get to read it, understand it. How does it operate? Obviously, I think there's a lot of work to be done in terms of coming up with a much, much more up-to-date Labour Act that speaks to the realities of what employees and even employers are also going through during this period. So the Labour Act is one of the fundamental statutes that we need to familiarize ourselves with in order for us to understand the laws that are governing contracts of employment. So the question that I always tell people is, or ask people is, if you've managed to do 1, 2, 3 and act, the next question you need to ask yourself is in terms of what law did you do that? So your actions, your decisions need to be supported in terms of the law. If it's not supported in terms of the law, it means that conduct is illegal. So from the Labour Act, you've got your collective bargaining agreements. And collective bargaining agreements, this is now the spirit of parties meeting, associating, discussing, saying, how can we come up with favorable positions And the position of the law is that a collective bargaining can only become binding once it has been registered in terms of Section 79 of the Labour Act. So collective bargaining agreements are also very important in terms of the provisions that govern specific contracts. Then one thing that has also contributed in terms of our understanding of employment contracts is something called judicial precedent. How has the court in the past dealt with matters? That's where you find judicial precedent, your labor court, your high court, your Supreme Court, your constitutional court. So once we get an understanding of these particular sources, it's going to enable us to have a better appreciation of employment contracts. And the point that I need to make as well, whilst running off on this, is the contract has to be lawful in the context of the sources of law. The contract has to be lawful in the context of the sources of law, meaning from all these sources, we need to be able to justify a particular contract, the obligations that are found in terms of the contract. By the way, common law, even if you don't know it, it's still binding. That's one of the things that people need to understand. So invest in your knowledge, reading and understanding of the rights, the obligations of an employer and an employee. So when we're talking about a dispute, what usually results in disputes is a violation of the common law obligations, violation of the statutory obligations. So once an employer or an employee violates the obligations imposed by common law, imposed by statute, that's when you begin to say, oh, okay, we've got a dispute, we've got a problem. So that's why I think it's very important for us to get to this understanding of what are the laws that govern contracts of employment. I want to take you to a pertinent point, which many people overlook, which is something called terms of a contract. What are the terms of a contract? So the terms is the particular contents that we've managed to agree on. We have agreed on 1, 2, 3, 4, 5. But the terms can be categorized into 2. And this is very important because the way some contracts are actually drafted, they don't particularly pay attention to these things. So the terms of the contract, you're looking at what are called express terms. Express terms, what it simply means is if we go into a contract, what is expressly provided for in terms of a particular contract? These are your express terms. So when you go into the written contract, what are the terms that we find in terms of that contract? So these are the express terms of the contract. Then there are things that are called implied terms. So I hear many people saying, no, that was not provided for in terms of the contract. No, that was not there in the contract. No, it doesn't work that way. Terms are implied by the law. That's what we need to state, and people need to appreciate this. Terms of a contract are implied by the law, meaning even though as the employer and the employee, you didn't provide for 1, 2, 3, 4, 5. The particular terms that are not provided for expressly are to be found in the provisions of statute. For example, let's say somehow you've signed an agreement which is not speaking to leave. Leave does not arise by operation of a contract. Leave arises by operation of the Labour Act, meaning even if you don't write it, that is specifically provided for by the Labour Act, meaning that's an implied term. You've got an obligation, you've got a duty to comply with the provisions of the law. So you need to understand that the implied terms are implied in terms of common law, they're implied in terms of statute. So many people, they say, okay, we're having some disciplinary issues with a particular employee, but the contract was not saying everything in terms of the conduct that they are supposed to do, they are not supposed to do. The common law places an obligation on an employee of good faith, the duty of good faith. So that might not expressly be written, but that's implied by common law, meaning there is an obligation by the employee to abide by that, the implied terms of the contract. So two things, express terms, what is specifically written in terms of the contract, implied terms, these are implied by virtue of statute. And the point that I also need to explain here is whatever that you agree as an employer, as an employee, needs to be legal. Legality, very important. And I'm going to touch on that in the next few seconds, the importance of legality in terms of the contract. So what are the elements of a valid contract of employment? And I think this is the question that many people will be asking. What are the important elements of a valid contract. Number one, it has to be voluntary agreement. In other words, you don't force a person into an agreement. Why? Because by operation of the law, this has to be voluntary. The parties need to agree. And once they agree, the element of voluntariness comes out. The opposite of voluntary is slavery. So it has to be voluntary. Number two, the employee should be a real human being. And people don't understand this. A contract of employment, you are hiring a human being, but an employer does not necessarily have to be a human being. An employer does not necessarily have to be a human being. It cannot be an official person. So a company can employ, an organization that's registered in terms of the law can employ, any other organization that has got legal status can employ. But the employee at all material times has to be a real human being. Then point number three, there has to be an agreement to be rendering personal service. And this is key, rendering personal service. By rendering personal service, what I was simply saying is you don't delegate. I think I made this point earlier. You don't delegate that I'm sending XYZ to do my part today, because the agreement is to render personal service, and there is an obligation by virtue of the common law to obey the orders of the employer. So if you fail to obey, that's when you meet SI 15 of 2006, which is providing for an offense called willful disobedience. Willful disobedience to a lawful order. And that's why I think it's very important for us to have an understanding of this. Then obligation number four, which makes a contract valid, is that an employee is supposed to be paid a wage. Because that's the opposite of slavery. So remember the definition of an employee that we gave you earlier on. There is an obligation to pay a wage, pay a salary. And these are some of the elements. And I'm just touching so that we get to benefit as well. Then what are the formalities of a contract? For a contract to be valid, I think we've been touching this earlier in the earlier slide, but I'm just emphasizing here. It has to be lawful. In other words, whatever that you're agreeing, the subject matter that you're agreeing has to be lawful. And that's why I said, let's go back to the sources of law. What did the parties agree to? Then number two, the parties should have capacity. By capacity, we're talking about legal capacity. So the person that's employing must have the legal capacity to actually employ. Many people might not understand why it's very important to say legal capacity. Because if you're not a legal person at law, it means you have no capacity to enter into agreements because you don't exist. So the employer has to be either a human being, either an artificial person, and by virtue of being either a human being or an artificial person, that is when the capacity comes through. Then capacity insofar as the human being is concerned, what it simply means is they have to be in a position to enter into contractual obligations. In other words, they need to have an appreciation of what they are doing. So capacity is very important. Then whatever that you're agreeing upon, it has to be capable of performance. It has to be capable of performance. Then it should be certain. Now, certainty is speaking to the importance of clarity. Are we of the same mind? Are we agreeing to the same mind? So this is very pertinent as well when we are coming up with our written contracts. Then I want to take you through Section 12 of the Labor Act. I think I pointed it when I was doing the scope just to present it to you. Section 12 is a fundamental section in terms of the Labor Act, insofar as contracts of employment are concerned. It's a fundamental section. Why? Because of what you're going to see now. So Section 12 actually gives us a definition of what an employee looks like. Every person who is employed by or working for any person or receiving or entitled to any remuneration in respect of such employment or work shall be deemed to be under a contract of employment with that person, whether such contract is reduced to writing or not. And I think this is where some of the confusion comes. I hear people saying some dangerous statement like, I don't have a contract and so forth. A contract of employment comes into existence by operation of the law. That's what we need to stress. A contract comes into existence by operation of the law, whether that contract is reduced into writing or not. But what gives rise to a contract? What gives rise to a contract is having a person who is employed or working for another person and is entitled to receive any remuneration in respect of such employment. So once we satisfy that, it means whether or not you write it down, that person has a contract of employment. So I hear many people say, you know, I've been working for a particular company XYZ for the past 5 years. I'd not have any contract. No, nothing was ever done. We didn't get any contract whatsoever. That's not correct. Even if you're not holding a paper, let's say you are employed, but as long as you're satisfying the conditions, as per the definition of section 12(1), it means you are under a contract of employment. And that's very important. That's why I was saying the contract is deemed to exist as long as the above is satisfied, whether it's written or not. That's why it's incorrect to say, I don't have a contract. And why is it very important for employers to actually regularize and ensure that your employees have written contracts? The advantage is certainty. When a dispute arises, you always have to go back to the written contract. So it's very dangerous for an employer to work with people who don't have any written contracts. That exposes you, because in the event of a dispute, you are vulnerable. That's why it's very important to get that point where you're saying, okay, let's write it down. That's why section 12 subsection 2 is very important. Section 12 subsection 2, very important. Why? Because it's actually imposing an obligation to itemize in writing. It's saying shall. It's imposing an obligation to itemize. And what are you supposed to itemize? Number one, the name and address of the employer. Why is this important? Because I've experienced a number of times where you go to court, a particular employee has been dismissed, you go to court, you're challenging the dismissal, then actually realize, no, well, actually, alternatively, the people are dealing with the wrong thing altogether. Why? Because the person who did XYZ is not even a person. Consequently, they can't be an employer. So the name and the address of the employer is very important, so that you know who the employer is. Very important. And I think there are some of the things that we take for granted, yet they're very, very important. So the name and the address of the employer is very important. Then secondly, the period of time, if limited, for which the employee is engaged. So the duration of that contract is also very important. Then the terms of a probation. These are by operation of statute. The terms of probation, if any. And we're going to talk about probation. So if a contract of employment is not providing for probation, you can't turn around and say you are under probation. No, it doesn't work that way. The contract has to specifically provide for probation if that's your intention, that you want to put an employee under probation. But if you're not providing, then the law is saying that there is no probation that is provided for. Then D, the terms of any employment code. Why the employment code is very important is because when you've got disciplinary issues, we need to know which code are we going to tend to. And one of the articles I was writing on how to conduct disciplinary hearings, also going to do a training that. Was a number of hearings that are done, they are done in a bad way, and consequently, that's when you find people having to pay some significant damages simply because people did not know what to do. So in terms of any employment code, what is the applicable code that is used in this particular instance that has to be provided for? Particulars of the employee's remuneration, its span of calculation, and the intervals at which it will be paid. This is also critical for certainty. Remember the conversation that we said, it's important for a contract to be certain. What is it that we're agreeing upon? Particulars of benefits receivable in the event of sickness or pregnancy, hours of work, particulars of any bonus or incentive production scheme, particulars of vacation leave and vacation pay, particulars of any other benefits provided under the contract of employment. So what happens if the employer does not provide these in writing? Remember what I said, those terms are implied by operation of the law. Meaning when we're looking into these things, now we go to the Labor Act. We go, in the case of non-managerial employees, we go to the relevant collective bargaining agreements in order to find these particular benefits. But most importantly, I think we need to stress the point that we need to get to a level where we promote certainty in contracts. Let's look at the forms of contract. What are the types of contracts that are available? Number one, in no particular order, we've got probation contracts. So pretty much the whole idea of a probation is to test suitability. Are you really suitable? This is traceable to the times of Henry Ford, the 90-day rule. can we work with you? And how do we do that? We test you for a period of 90 days. So the probational periods are provided for in terms of the Labor Act as well. So when you want to put an obligation on an employee to satisfy a probation period, that is to be expressly provided for. But if it's not, like I mentioned, that is out. But during the probation period, you also have an obligation to ensure that if you want to terminate the contract, that is to be procedurally and substantively fair. CBZ versus Kwangwari, it teaches you a bit on what is meant by unfair termination and what happens if you want to deal with an employee who is going through a probation contract. Then section 12.5, a contract of employment, that's section, a contract of employment may provide for in writing for a single non-renewable probationary period of not more than 1 day in the case of casual work or a seasonal work, 3 months in another case during which notice or period of termination to be given either party, maybe 1 week in the case of casual work, seasonal work, or 2 weeks in another case. So what the Act is now doing, section 12.5, is now specifically providing for the periods when you want to put a probation clause, but also the termination periods as well. But the requirement is, number one, it has to be a non-renewable probationary period. So, and then the employers, they make this mistake. You see that your employee is not performing very well. The 3 months has come. Now you don't know what to do. Alternatively, not been properly advised. Some employers usually tend to extend that period. So if 3 months goes, and you haven't done anything, there is now a judgment of the Supreme Court that says that particular employee is now a permanent employee. That's why you need to put in place systems to monitor the performance of the employees during the period of the probation, and not just wait for the 90 days and say on the 90 days they failed. That's not how we do it. We need to be mindful of the requirements to stick to the substantive fairness and also the procedural fairness. And the next type of contract is very important, is the permanent contracts. So these are contracts which have no duration or which are silent on their duration. A permanent contract may be full-time or part-time. So you can actually be permanently part-time or permanently full-time. So it's very important to understand that. But there is also an obligation in terms of the law, which actually specifically says that a contract that does not specify its duration shall be deemed to be a contract without limit of time. So if you just employ a person and you don't speak in terms of duration, what it simply means is that person is on a permanent contract. The other type of contracts are your temporary contracts. Pretty much, these are also specifically provided for in terms of the contract itself, and they expire on the specified task. So if you do 1, 2, 3, 4, 5, that's it. So you've got to type your casual contracts and your contract for seasonal work, which is defined there on the screen. Then there's something that we need to pay attention to, called the amendment. So when the Labor Act is amended in 2017, it actually does something very interesting when it came to contracts that spoke of their duration. And this is what section 312.3a says: a contract of employment that specifies its duration. So that type of contract that specifies its duration or a date of termination, that's your fixed term contract. In other words, you're here for 2 days, you're here for 3 months, including a contract for casual work, seasonal work, or the performance of some specific service, shall, despite such specification, be deemed to be a contract of employment without limitation of time upon the expiry of such period of continuous service, as is fixed by the appropriate employment council. So right now, section 3A is introducing a disruption to the idea of a fixed term contract. Why? Because it's now looking at this whole concept of the period of service. Then that period, that continuous period, is now being fixed by the National Employment Council. So now many NECs have now started putting in place collective bargaining agreements that speaks to the period that we're looking at. And once that period has been satisfied by operation of those CBAs, it simply means a person becomes a permanent employee. And in the event that there is no NEC, that's when the B comes through. It's simply saying that in the absence of an NEC, the minister is coming through to make those regulations and fixing that particular period. And what it means, that particular employee becomes a permanent employee, and they're entitled to the same benefits as are in the Act or any CBA provided for those employees who are engaged without limit of time. So this section 12.3a is very important. We need to pay attention to it to ensure that when we're making decisions, we are quite clear about this. Then fixed contracts, I think we've explained about fixed contracts as well. K International versus Magodora, you might want to read it. It's very interesting in terms of fixed term contracts. Then it draws against the background of the argument of casualization of labor, where people say, no, we're being casualized, we're being abused, etc., etc. It comes to define what is a fixed term contract. Then variation. I promised to talk on variation a bit. An employer has the right to vary terms of a contract in regard to things like location. In other words, if you are employed and you're working in Marara, unless your contract says you are not going to be transferred, the position of the law says an employer, if he has obligations and operations outside, that are spread throughout the country, they are entitled to transfer an employee anywhere in the world. And I want people to understand that, because I see many people trying to challenge their repost in some other town and so forth. You can't do that, because that's a variation of a location. The job description can also be varied, as long as there's no variation of material elements of the contract or the status of the employee. So I hear a number of people saying, no, you can't change my contract. No, a contract can be changed. And I want you to read Namo NO versus Kirasasa. That's the Supreme Court. It stresses the importance that the contract cannot remain fixed in an environment that is changing. Contracts are going to change, and they actually have to change in order to meet the needs of the business, in order also for them to meet the commercial convenience of the business. So a number of people don't understand the concept of commercial convenience, that you also need to make decisions that are in the interest of the business in order to keep the business afloat, to keep the business running. That's where variation comes through. But variation, for it to found the cause of action, it has to be a material, unilateral material variation of the contract. That's when you can say there is an issue that has arisen. Then I promise to close on this. We're actually going to have a separate conversation around issues to do with terminations. That's the issue of termination notice. I think I need to stress a point. The law did not abolish termination notice. It simply regulated it. So contracts can still be terminated on notice. If you go through section 12.4a, you can actually go through and see that there are certain contracts that can actually be terminated on notice. One of them is a fixed term contract. It can be terminated on notice. And many people are, I don't know why people are so excited saying, no, they can't be terminated. It can be terminated on notice. So section 12.4 was not removed. Why? Because it's providing for termination on notice periods. Section 12.4a is providing for specific instances when termination on notice may be done. And I think it's very important to also understand that. In the next conversations, we are going to cover things to do with termination so that you can get to fully understand how these things operate. Goma memory, it's been an honor speaking to your wonderful team here. And I think many people really have questions. I'll be very excited at this stage if there are any questions so that I can start interacting and relating to one or two questions.
Thank you very much, Arthur. Maybe you can take questions. You can put your questions in the chat room if you can, or you can raise your hand. Then we allow you to speak. We'll take questions. Maybe let me check some of the questions here. And where can I turn to this one? And where can I turn to fair remuneration after one agreed was eroded by inflation? Also, what can I do if my salary is long overdue, like 3 months salary arrears, but it's still not the right time to leave? Staying and living is kind of dilemma. That's one of the questions, Arthur, for you. Arthur?
So remember, the obligation of the employer is to pay a salary. And if the employer is not paying a salary, that becomes a breach of the common law obligation to pay salaries, also fair labor standards. So the option we have, engage your employer. If you can't engage your employer, now you might need to activate the necessary processes that are provided for your workplace. If you're NEC graded, now that's when you can refer the matter for NEC for it to determine that matter. If you're not, you can go to the Ministry of Labor. That's actually a very straightforward matter. And guys, if a business is failing to pay salaries, it's really wrong to keep employees in the dark as to why you're not paying salaries. It's rather better for employees to know that things are not happening. If need be, we might need to engage into anti-retrenchment measures in order for us to get to a position where we are now protecting ourselves from possible litigation. So I really think it's important for employers particularly, because there is an obligation in terms of Section 12 CD of the Act to keep the employees posted of the developments, the changes in means productions of the business, so that they are not just surprised. So if the employer is not paying, you might have to utilize some of the available options in terms of the law to ensure that you have got your interests protected. At the same time, I'm also well aware of the fact that it may also strain relations. But guys, come on, this is a contractual obligation. It has to be paid, it has to be honored. If the employer is struggling, there are also available mechanisms to deal with that. And I think this is a point we need to ensure that you need to be able to be aware of the available options in terms of the law as to what you can do to protect yourself if the business is not operating well, if the business is no longer able to meet its obligations. I think that would be my response to that. Then I think it was for that question to do with salaries, but I think it's actually a straightforward matter. It's not a complex matter.
Okay. Another question: we engage guards 1 year renewable contracts are paid. They are paid $60 to $100 US. Should we register them under NASA? They can walk away anytime, but some have renewed for 5 years now. That's another question there for you, Arthur.
All right. Pretty much, I think it's that understanding of the law that governs Social Security. I think you might need to engage NASA itself directly, but I think there should be an obligation because they are still employees for all intents and purposes. You need to actually do that. But obviously, when the changes have occurred, you can still make the relevant notifications. These same guys, regardless of the fact that they are on a 1 year contract, they still have tax obligations. And the employer also has got tax obligations insofar as these particular employees are concerned. So regardless of the duration, the legal obligation, they still apply and they're still binding. Secondly, insofar as the minimum wages are concerned, these are governed, number one, in terms of the collective bargaining agreements, which sets the minimum. Secondly, in terms of the employer and the employee agreeing to even better standards. I think that's one of the things that we need to clarify here.
Okay. The other question, there are quite a few. I'll pick and by one we should be done if there are still more questions. When a fixed term contract is not going to be renewed and it's stated that it will be renewed, what's the best way to handle such a scenario to avoid litigation? All
right, so if a fixed term contract is not renewed, remember Section 12B, the question of legitimate expectation arises. So if someone was on a fixed term contract, it expires and there's a legitimate expectation to be renewed, that can give rise to a claim of unfair dismissal. So the best way is to ensure that the way you couch your contracts needs to address and speak to the issue of legitimate expectation. There is actually a judgment that speaks to that particular case on where employees specifically sign agreements where they're saying they're not going to entertain any legitimate expectation of the contract being renewed. And as a matter of fact, you still need to have that provision even if you're going to renew that particular contract. So that when you're renewing it, it's not as a matter of obligation, it's as a matter of discretion. Why? For a business, one of the things that you need to actually do is to ensure that you cover yourself, you protect yourself against potential litigation, especially from Section 12B on fixed term contracts, where issues to do with legitimate expectation may arise. So I think it goes back to the couching of that particular contract.
Yeah. The other question, Arthur, is that someone resigns, they don't give notice, and the employer says, I'm going to take your pension, I'm going to take all your terminal benefits to cover the period of notice. What is the correct position in terms of the law?
Section 13 answers that. That's actually illegal. Well, Section 13 says it's a criminal offense for an employer to withhold terminal benefits without a certificate from a minister doing that. But obviously that's what many employers do. They just hold on to the salaries and so forth. But if an employee decides to actually take the criminal route, they can actually get that, because by virtue of a Section 13, an employee, whether they are dismissed, whether you resign, you are entitled to get your terminal benefits. So that practice, truth be told, I don't think it's legal, because there is an obligation to say, if you want to vote, get ministerial approval.
Yeah, it's actually worse. There's another message here that says, can an employer follow up on a notice pay after the employee is late? It's actually worse. The employee has died and someone is still following up on notice pay.
they want their money because they didn't give us notice. So you see what happens. The reason why in the Zua matter the argument was the employer can terminate on 3 months notice is because the employee can also give notice, say I'm going. That's pretty much. So if we've signed contracts that provide for notice, let's also try to give the notice. I think that's the point we need to also emphasize from the employee's end. Let's also tell the future employer that, dude, or wait, I've got an obligation that binds me to give 3 months notice. I'm in a position to cover that in the event that I resign without giving notice. Because the moment you agree to giving 3 months notice before you can terminate your own contract, it also means you're also breaching the provisions of the contract that you signed. So I think it's something that we also need to be very considerate as well. Because the whole idea of notice is the employer needs to make arrangements to replace you.
Okay, good. How do we treat NGO contracts which are continuously being renewed? All
right. It goes back to the question that we're talking about in terms of the renewal of the contracts. That a contract that specifies its duration, blah, 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 that section 12.3a, that amendment. The only cure to that is the minister coming through and fixing a period of continuous renewal. But until that period has been fixed, it's not going to be good for the people who are working for NGOs. By the way, NGOs, they work with budgets that come from donors, I think. That's one of the things. That's why I think many NGOs are coming through and saying, we can't give you permanent contracts because these are donor funded. But for the employees to really say, I now want to be permanent by virtue of the Labor Act, we need the minister to come through with a statutory instrument to fix that particular period. But if you're not covered under the minister section, you're falling under an NEC, the question is now, what does your particular NEC say in terms of you being covered insofar as the issue of continuous renewal is concerned?
Okay. On elements of valid contracts, you mentioned that employees are supposed to be paid a wage. So what is the status of those situations where the person is recruited to volunteer, e.g. in NGOs?
All right, I'll tell you one thing. If you satisfy the requirements in terms of how you perform, and you are actually satisfying the requirements of an employee, the whole idea of a voluntary arrangement is disregarded. By the way, the contract, remember what I said, the contract, the conditions have to be legal in the context of the sources of law. So sometimes people are being disguised as volunteering when they're actually doing the work of the employees. In that particular instance, that whole arrangement can be challenged. A contract of employment can be deemed by operation of the law. Then they can probably claim the benefits as provided for in terms of the Labor Act and the CBA.
Okay, let me look for a few, some of them are repeated questions, so quite a number of them here. Let me just speak. It says, if one is signed more than 6 consecutive contracts, does this mean he is now a permanent employee? If so, is the employee entitled to medical aid, funeral premium, benefits given to others, although not explicitly stated in the contract?
All right, I think let's go back to the sources, the conversation around the sources here, where we said the period of continuous renewal has to be fixed in terms of a collective bargaining agreement by the NEC, alternatively by the minister. So the question is, do we have a particular NEC collective bargaining agreement that's saying if you have worked for XY number of years, your contract has been renewed for XY number of times, you are now permanent. In the absence of that, you are still on a fixed term contract. You can't say, because I've been doing this for the past 10 years, now I'm permanent. You don't make yourself permanent. You're permanent by contract, you are permanent by the provisions of an act.
Okay, thank you. On the right of the employer to vary the contract in line with changing conditions, how far is the extent of discretion of the employer to tamper with remuneration?
All right. So one of the things that people need to realize is the case of Air Zimbabwe versus Zendera. Air Zimbabwe versus Zendera, Air Zimbabwe increased salaries for the flight attendants without even their knowledge. The next thing, these guys realized, they decided to reduce and they were sued. Why? Because once people accepted that increment, that became a valid contract. So you can't unilaterally vary that. So when it comes to the salaries, you don't unilaterally vary a salary. You engage the employees. Once you engage the employees, secure an agreement. If there's no agreement, you now move into the next available options. One of them is retrenchment. Anti-retrenchment measures, eventually retrenchment. But you cannot just wake up and say you were earning 500, now it's 250, in the absence of the relevant process to say that this is what we're doing. So Section 2A1E of the Labor Act provides for the protection and promotion of participation of employees in decisions that are affecting their interests. So it's not every time that the employer has got that power. Remember, the rights to vary is not unqualified. The right to vary has to be exercised within the context of the fair labor standards.
Okay, good insights there. The compliments are so many, I will not read them. I will just focus on the questions. The company is registered outside Zimbabwe and would like to start operation in Zimbabwe. Should we register a company in Zim to be under the constitution of Zim, or what is your recommendation in employing people locally, protecting them and protecting the company?
All right, so for starters, if you're not yet registered in Zimbabwe, you don't exist. Meaning you need to register in terms of the Companies Act, then you acquire personality and you fall within the jurisdiction of the Zimbabwean laws. Automatically, the Constitution of Zimbabwe goes, you're now a person. So once you do that, then we can now talk about your contracts and so forth. Then the Zimbabwean law is now operating. So in as much as you can even be an international company, but insofar as you're in Zim, you need to have some form of existence which recognizes you as a person, which means that part of your business falls and is covered under the Zimbabwean laws that govern labor relations.
Okay. If on retrenchment you reach an agreement at Works Council, you meet the minimum conditions. However, individual employees disagree on the terms and keep refusing. What will be the recourse as the retrenchment board is now insisting on individual agreements?
You know what happens now is if the parties have engaged and failed to agree, what the Labor Act has done is it has provided for a minimum retrenchment package, 1 year salary for every 2 years worked. That becomes the default package that is to be paid to the employees. So that the retrenchment board is insisting on individual agreements. I know that's not legal. It doesn't have that power because now the role of the retrenchment board is specifically provided for in terms of the Labor Act. The retrenchment board now, the retrenchment board is different when you're now looking at them. Because you see, the role of the retrenchment board now has been so much limited because it's no longer the retrenchment board that determines the packages. The packages have to be agreed between the parties. If the parties are not agreed, you go to the Labor Act. And once you go to the Labor Act, there is a minimum package that is applicable. So it's not correct to say the retrenchment board is saying go and have individual agreements. That's not correct. If necessary, they've got problems with them again, is also the retrenchment board.
Mm-hmm. That's correct. I think that is very, very correct. It's an important point to take note. Then another question. So we have got 7 minutes to go, Arthur. If you can, there are too many questions here, so I will allow them to ask so that they get the value. Since maternity leave is paid, is it possible to send the employee on unpaid leave because of COVID?
All right. Is it? No. There's nothing called unpaid leave. You see, one thing that people need to understand is maternity leave is authorized absence by virtue of pregnancy. Then, if you think you're broke and your business cannot afford to pay, I've told you the options. Secondly, if the employee wants a period longer than the period given for maternity, now that's when we can talk about unpaid leave. But you don't just wake up and say, no, you're going on unpaid leave. No, it doesn't work that way. Remember, the obligation of the employer is fixed in terms of the common law, which is to pay salaries. You have the obligation to pay salaries, the obligation to provide work. And I think it's very important to understand that. If you're going to send an employee on unpaid leave, that is to be specifically agreed by the employee. You cannot unilaterally say you're going on unpaid leave. It doesn't work that way.
Yeah, there's a break there, Kudzi. What is happening to the connection there? Arthur seems to have been disconnected. Is that correct?
Yeah, I can hear you. I can hear you. I can hear. There's a question. What is the minimum wage in Zimbabwe in USD? Please, thanks. No, there's nothing. You see, the minimum wage, the concept of a minimum wage is not uniform. It can be minimum for one particular sector. The amount is different. For another sector, the amount is different. So I think people need to understand that you need to look at the particular sectors. What is the particular sector that you're looking at? And from there, that's when you can say, oh, okay, there's a minimum wage and so forth. And again, the issue of minimum wage in USD, it's something that we need to understand. We might not be seeing it very soon by virtue of the issues to do with the currency. So what you can see is to see benchmarking of salaries using the USD. I think that's what we may actually see. Memory, are you still there? I don't seem to see memory, but let me just go to the chat board.
I'm there, Arthur.
Ah, better.
Sorry, I was booted out, but let me continue some of the questions.
All right, so
okay.
Yeah.
I think this one, what benefits accrue on voluntary termination of employment? To whom is the minimum package or loss of employment compensation limited to? I think you can answer those while I'm opening that.
Right, so what benefits accrue on voluntary? The key word there is voluntary. It's the benefits that you're able to negotiate. It's not like so the moment the law says this is the amount, it's no longer voluntary. It's now statutory. So voluntary simply means it's what you've been able to negotiate, bargain for, pretty much. But there's no minimum to talk about. But when you terminate your agreement on voluntarily, alternatively, it's mutual termination, you can still obviously get more benefits in terms of Section 12C, the benefits that are provided for. You can get your 3 months notice, your 1 month salary for every 2 years, but pretty much is the minimum. There's no actually minimum, yeah.
Okay, there's another question here. When an employee refuses to sign a contract, what do you do? Can you consider that no contract, no work, and look for replacement right away?
All right.
Same contracts usually for executives. The executive, I think, refuses to sign a contract.
All right, so this is what we need to hear. When I was saying an employee has refused to sign a contract, number one, how do they become an employee without a contract?
I want to put if I want to put my Skype.
I think there's can that person meet themselves, please?
So,
can you meet that person?
Yeah.
Carol Arthur?
All right, so when I was saying an employee is refusing to sign a contract, we need to be very clear. Because if they are an employee, they're already working for you. The question is, on what terms are they working? Then be mindful of the fact that if they are working without a contract that's written, they're already permanent. You can't now say, come and sign a fixed term contract unless they've agreed, because that becomes a variation as well. So, but if they're on a fixed term contract and you're inviting them to sign another fixed term contract and they refuse to sign, it simply means once the fixed term contract comes to an end, the contract ends. You might as well notify them.
Okay. What happens, Arthur, another question, in case where someone is on a fixed term contract for 5 years, on 3rd year into the contract, we run out of funds and we want to terminate. What is the procedure? All
right, so someone is on a contract of fixed contract of 5 years, you run broke, you don't have money. You can just terminate it on notice. Just give 3 months notice. Oh, by the way,
okay.
3 months notice, the 3 months notice thing still applies. That's what I was saying, people don't understand this thing. If you are employed on a fixed term contract, you can be terminated by just being given 3 months notice. So we don't have to do retrenchment. We don't even need to do the other processes to say, let's negotiate a package. Because ordinarily, if you dismiss a person unfairly who's on a fixed term contract, the damages simply means the rest of the contract. That's what you pay for the damages.
Okay, amid this COVID-19, the event that another lockdown or shutdown comes into effect, how can organizations address the issue of rewards when they are not producing or generating income?
Now, you go back to the terms of that contract. You go back to the terms because, you see, the rewards are based on production. What did we produce? If there's no production, it means there's no reward. Secondly, these are the particular terms where you realize that the contract cannot remain stagnant. I think we made that point. The contract cannot remain stagnant. And during a lockdown, if we are going to go through a lockdown, this is the time where you can say, guys, we need to consider anti-retrenchment measures. We're going to suspend 1, 2, 3, 4, 5 benefits. Just to make that afloat. The business running. So
okay.
There are many, many options that are available for an employer to utilize in the event that we are going through what we're going through right now.
Okay.
Yeah.
Can an employer impose a new job grading system without negotiating with the employees? How does an employer legalize a new grading system?
All right. Remember the question on the grading system, pretty much that becomes variation. The employer can still change in terms of the job description, but the qualification is the employer cannot affect the status of the employee. In other words, if I was up there, you can't bring me low there. What the law is simply doing is simply to set minimum standards. That's what we need to understand. The law simply sets minimum standards. So if you're doing anything that's going to affect detrimentally the interests of the particular employee, that becomes illegal. But at the same time, an employer is allowed to restructure, change the model. If the people are there and they don't necessarily want the change in the model, remember, the available options. So regrading and so forth falls under operations. If they change in terms of the operations, how the employer is running its affairs, running its business, that also becomes a basis for an employer to undertake a retrenchment exercise should there be difficulties in proceeding.
Okay. Can an employer deduct leave days for the period for the period employees were not coming to work due to lockdown?
No, you can't. Why? Remember, leave is authorized absence. Secondly, depending with the model of your business, I can actually be at home working. So what has simply changed here is I'm not coming to a physical office, but I'm working from wherever I am. So you can't say I'm on leave when you're actually sending assignments to me to work and I'm actually doing that work that you give me. Secondly, the obligation of the employer is to provide work. If you're not providing work, there is no way that you can't say that I'm not working, because the employee's obligation is to render service. Now they can't render service by coming physically to work because of situations that are beyond their control. Now there are regulations to say you can't go to work unless you're essential service. So if the employer wants to do the smarter way, you might as well ask your employees to go on leave during that period of time. Yeah, because the leave by definition is simply the employer authorizing an employee to be absent. So rather than to deduct, you need to engage, say, guys, since you're staying at home, you might as well go on leave. But not to deduct money. It's reducing your days. No, it doesn't work that way.
After a probation contract, do we get to sit down again to renegotiate the remuneration?
Pretty much it's what you agree upon. There is no law that says, when can you sit down? You can even sit down and agree on your salary from the onset that your entry remuneration is XY amount. Number two, once you've successfully completed your probation, XY amount begins to become your new salary. So it's pretty much within the province and the remit of your ability to negotiate and discuss with your employer.
Is it legal for an employer not to allow me to go on my maternity leave 4 times?
All right. So the way our Labor Act is structured, there seems to be a limitation in terms of the number of months, the number of times you can go on leave. And I think that's an area where the law needs to be tested in terms of the constitutionality, where a person says they want to go on leave for the 4th time. So now the Labor Act is saying what it's saying. We now have a constitution which is under a new dispensation. I think the best, depending with your resources, might be to be taking a test case to the relevant courts to ensure that particular provision is tested. There was an attempt to challenge it. Somehow it wasn't pursued, but I think it should be pursued. It's quite critical, because as an employer, you can't tell me the number of children to have. That doesn't make sense. What if I want 10?
Then the other ones, I think some of them have been answered. I think we're on 3 past. Arthur, I think we've done an hour.
Thank you so much.
Thank you very much for this wonderful presentation. I think probably our next presentation should be on disciplinary matters, which is another hot issue. So we'll advise the participants. We had slightly over 200 participants. We had 600 registered. But that's the norm. Others then get other appointments that coincide with this particular presentation. But we are very happy with the attendance so far. Probably one of the most attended sessions in terms of numbers, because you are speaking to the things that are at the heart of the employment relationship. And these are crucial issues that people have questions on. What we may also do is in future, we may actually have just a Q&A where you go on our platform and Arthur will answer some of the questions there. Pick some of the topical questions. We'll arrange that with Arthur. Otherwise, thank you very much, Arthur, for agreeing to come on this particular platform.
Thank you so much for the invitation.
Yeah, and Arthur is our partner. And also you're free to contact Arthur should you need any help in terms of how you can, as an individual or employer, that's why he's a lawyer, so that he can assist you in terms of that. And also, as we heard, he's a speaker as well. We do collaborate with Arthur on a number of issues. So you can get hold of him. You can contact us, or if you get hold of Arthur and we can do something for you, you will pass the message to us. So it's a win-win situation with my young man here, Arthur. Thank you very much, Arthur. And to all the listeners, all the people who came to watch this particular presentation, we really value your contribution. The questions were so many. The thank yous, Arthur, are just too many. I can't go through them.
Thank you so much.
There are so many, and they are pouring. You can go into the chat room. Kudzime, you can leave this on for about 5 minutes so that people can just put in their comments while we wind up, and also leave our adverts on there while we wind up. Thank you very much. Enjoy the rest of the day.